In this video, we will look at False Claims Act lawsuits against nursing homes. If you have evidence that a nursing home is engaging in fraudulent practices, you can bring a whistleblower lawsuit and get a percentage of any money awarded in the case. A whistleblower is a gatekeeper in the American workplace. These are the people that see something wrong or illegal and have the courage to take action. Whistleblowers help keep businesses accountable to the government, and for their good work, whistleblowers can make some real money. So how does it work? Under a federal law called the False Claims Act, companies that receive money from the federal government can be subject to civil liability if they obtain that federal money through fraud or false pretenses. The False Claims Act authorizes private citizens with knowledge of fraud to act as whistleblower plaintiffs and file suit on behalf of the federal government. If the case is successful, the whistleblower plaintiff gets to keep up to 30% of whatever money is awarded. We have a particular interest in nursing homes because there's so much cruelty and indifference in American nursing homes today. What we have seen during COVID-19 is what nursing home lawyers have been seeing for decades: nursing homes that put profits above everything else. A significant portion of nursing home revenues come from the federal government through Medicaid and Medicare. This means that nursing homes can be liable under the False Claims Act if a whistleblower plaintiff can show that the facility received those federal funds improperly. There are basically two categories of nursing home liability under the False Claims Act. The first is fraudulent billing, and the second is inadequate care. In this video, we will focus on whistleblower nursing home cases involving fraudulent billing practices. Fraudulent billing by nursing homes involves any deliberate scheme to obtain reimbursement that the facility is not legally entitled to through deception or false pretenses. Nursing home billing fraud can come in many varieties and circumstances, but we will look at the most common types. Upcoding is probably the most common fraud in nursing home billing. Upcoding occurs when the nursing home bills Medicare or Medicaid for a more expensive treatment or service than the treatment or service that was actually provided. An example of upcoding would be billing for a 1-hour consultation when the doctor only actually performs a 10-minute follow-up. Phantom billing is another fraud scheme at nursing homes. This occurs when the facility bills Medicaid or Medicare for patient treatments or services that were never actually provided to the patient. Other fraud schemes include performing services or treatments on patients that are not medically necessary for the purposes of increasing revenue, and receiving illegal kickbacks for patient referrals or service referrals. Nursing homes that engage in these types of fraudulent or deceptive billing practices cost the federal government an estimated $60 billion every year. If you have inside or direct evidence of a nursing home engaging in any of these fraudulent billing practices, or otherwise getting improper Medicaid or Medicare reimbursement, you can become a whistleblower plaintiff and bring a False Claims Act lawsuit. Call our office today to find out more.